The time is 11:18 at night, a kitchen in the suburbs of Chicago, Illinois. The light above the stove is still on. It is always the last light off in this house. A woman named Amara is sitting at the table. She has lived in the United States for 9 years. She has a green card, she has a job she loves, she has 2 children who were born here who know no other home. She is holding her phone with both hands. On the screen is a news alert, 4 words, new immigration law signed. She reads it 3 times. Then she sets the phone face down on the table. From upstairs, her daughter calls out, "Mama, are you coming to bed?" She does not answer because she does not know yet whether the answer is yes or whether everything is about to change. This video is for Amara and for everyone sitting at a table just like hers tonight. A new federal immigration law was signed in 2026, and if you hold a green card, it affects you starting now. Not in 6 months, not when your renewal comes up, now. This law changes the rules around green card renewals, continuous residence requirements, criminal background reevaluations, and, most critically, the conditions under which a green card can be revoked without a hearing. That last part. Read it again. Revoked without a hearing. If you do not know what changed, if you do not know what you are now required to do, if you do not know the 3 new tripwires that can end your permanent residency, then you are standing on ground that has already shifted beneath your feet, and you do not even know it yet. Keep watching, because the next few minutes could be the most important of your entire immigration journey. Before we get into what the law says, we need to talk about the mistake, the single most dangerous mistake green card holders are making right now. They are assuming that having a green card means they are safe. They are thinking, I already went through the process, I already got approved, I am permanent. Permanent resident does not mean permanently protected. A green card is a conditional privilege. It can be reviewed, it can be challenged, it can be revoked. And under this new law, the threshold for triggering that review process has been lowered. People are falling for this mistake because the word permanent is right there in the name. Permanent resident. It feels settled. It feels done. It is not done. Your green card is a living document inside a living system. When the system changes, your obligations change with it. The immigrants who will be hurt by this law are not the ones who did something wrong. They are the ones who did not know the rules had changed. That ends today. The first trap is the renewal delay trap. Your green card expires in 7 months. You have renewed before. You know the process. You are not worried. The truth, under the new law, USCIS has implemented a stricter continuous residence audit during the renewal process. Any gap, even one caused by a technical filing error, can now trigger an automatic request for evidence, delaying your renewal by up to 18 months. People fall for this because their last renewal was smooth. This renewal is not the same process. The rules are not the same rules. The correct move: begin your green card renewal no later than 12 months before expiration, not 6. File with a complete organized packet and include a cover letter documenting your continuous physical presence in the United States for the past 5 years. The second trap is the travel trap. You have a green card, you plan to travel abroad for 3 weeks. You have done this before. You know that less than 6 months is safe, or so you think. The truth: the new law introduces a secondary continuous residence trigger. Even trips under 6 months can now be flagged if your travel pattern shows extended absences across multiple years. Even if no single trip exceeded the limit, people fall for this because they memorized the 6-month rule and assumed nothing else mattered. The law just added a second rule on top of the first one. The correct move: before any international travel, calculate your total days outside the US over the past 36 months. If that number exceeds 365 days across multiple trips, consult an immigration attorney before you book your flight. The third trap is the criminal record trap. You had a minor offense years ago. It was a misdemeanor. You paid the fine. You moved on. It felt resolved. The truth: the new law expands the category of offenses subject to reevaluation during the green card renewal process. Certain misdemeanors that were previously considered low priority are now flagged for mandatory review. People fall for this because their immigration attorney told them years ago that their offense would not affect their case. That advice was correct. Under the old law, under the new law, it may no longer be. The correct move: pull your complete criminal record, every state, every year. Book a consultation with an immigration attorney who specializes in criminal immigration law. Do not assume your past record is a closed chapter. Under this law, it may have been reopened. The fourth trap is the public charge trap. You received a government benefit, a medical subsidy, food assistance, housing support. You needed it. You were entitled to it. You did nothing wrong. The truth: the new law expands the public charge review window during renewals and naturalization applications. Certain benefits received in the past 3 years, not 5, not 10, 3 years, can now be included in your public charge assessment. People fall for this because they were told years ago that green card holders are not subject to public charge review. That was partially true. The new law partially reversed it. The correct move: Document every benefit you have received and the reason you received it. Gather evidence of your current income, employment, and financial stability. If you are applying for naturalization within the next 24 months, speak with an attorney about how to frame your benefit history correctly. Now, let us talk about what the law gives you. Because this is not only a video about what can go wrong, this is a video about what protects you. The Immigration and Nationality Act, the INA, is the foundation of immigration law in the United States. It still stands. It still protects you. And certain protections within it were not changed by the new law. Under INA Section 240, you have the right to a removal hearing before an immigration judge. That right was not eliminated. If USCIS initiates removal proceedings against you, you are entitled to appear before a judge. You are entitled to present evidence. You are entitled to legal representation. Under INA Section 264, you are required to notify USCIS of an address change within 10 days. This sounds like an obligation, and it is, but it is also your protection. If USCIS sends a notice to an old address and you miss a deadline, failure to update your address will be used against you. Keeping your address current keeps your rights current. Under the Fifth Amendment, no person on U.S. soil, regardless of status, can be compelled to provide self-incriminating testimony. Not at a renewal interview, not at a border crossing, not at a routine check. If an officer asks you a question that could be used against you, you may say this: "I would like to speak with an attorney before answering that question." That sentence is legal armor. It is not rude. It is not suspicious. It is your constitutional right, and it is recognized at every level of the immigration system. And finally, the Administrative Procedure Act. This federal law requires that any new immigration policy follow a formal rulemaking process. If a new policy was implemented without proper notice and comment procedures, it can be legally challenged. That means not every enforcement action under this new law is automatically bulletproof. The law has limits. Know that. Here's your survival plan. 8 steps. Execute them in sequence. Start today. Step 1. Read the summary of the new law yourself. Do not rely only on social media posts or secondhand explanations. The USCIS website has published a plain language summary of the key changes. Read it, take notes, highlight what applies to your situation. Step 2. Calculate your total days outside the United States for the past 5 years. Use your passport stamps, use your travel records, use your email receipts for flights. Write the number down, know it before anyone asks you. Step 3. Pull your complete criminal record from every state you have lived in. You can request this through your state's Department of Justice or Attorney General's office. Do not guess. Do not assume. Get the actual record. Step 4. Update your address with USCIS immediately if you have moved in the last 2 years. File Form AR11 online at uscis.gov. It takes 5 minutes. A missed USCIS notice because of a wrong address can cost you your case. Step 5. If your green card expires within the next 12 months, file for renewal now, not at the 6-month mark, now. Gather every document: tax returns, employment records, lease agreements, utility bills, children's school records. Build a file that proves your life here. Step 6. If you received any government benefit in the past 3 years, document the reason and gather proof of your current financial self-sufficiency. Employment letters, pay stubs, bank statements, have them ready. Step 7. Book a consultation with a licensed immigration attorney within the next 30 days. Not to file anything necessarily, just to have someone review your specific situation against the specific changes in the new law. 1 hour of professional review can prevent years of legal problems. Step 8. Memorize this sentence and use it every time you feel pressured by an officer or official. "I would like to speak with an attorney before answering that question." That is not defiance. That is not obstruction. That is the law protecting you. If you are willing to use it, let us talk about what this looks like in real life. His name is Daniel. He has lived in the United States for 14 years. He has a green card. He has never had a legal problem. He is a construction supervisor. He coaches his son's soccer team on Saturdays. He is at the airport. He is returning from a 2-week trip to visit his mother, who is ill. He hands his green card to the CBP officer at the primary inspection booth. The officer looks at the card, looks at the screen, types something, then, "Sir, please step this way." Secondary inspection. In a room with fluorescent lighting and plastic chairs, a second officer sits across from him. The officer asks, "How long were you outside the United States this year?" Daniel does the math in his head. He thinks about the trip in March, the trip in July, this trip. He says, "I'm not sure exactly. Maybe 3 months total." The officer writes something down. Then, "Have you ever received government assistance?" Daniel remembers that 2 years ago, when work slowed down during the winter months, he applied briefly for food assistance. 3 months. He stopped as soon as work picked up. He says, "Yes, once, a few years back." The officer writes it down. Everything Daniel said was honest. Everything Daniel said became part of a file, and Daniel did not know that under the new law, both answers had triggered a flag. Here is what Daniel should have known going into that room. First, he was not legally required to answer open-ended questions beyond confirming his identity and presenting his travel documents. He had the right to request an attorney before answering further. Second, the phrase "I'm not sure exactly" is never the right answer in secondary inspection. It signals inconsistency. Before any international travel, calculate your exact days outside the US, write it down. Know the number before you get on the plane. Third, any benefit history should be addressed proactively, not volunteered casually. If he had spoken with an attorney before traveling, he would have had a documented professional explanation ready. Instead, he had an improvised answer that raised more questions than it answered. Fourth, the moment the officer said, "Step this way," Daniel could have said, "I would like to understand my rights in this process. Am I being detained or am I free to go? And may I speak with an attorney?" That question changes the entire dynamic of the room. It does not guarantee a positive outcome, but it forces the officer to define the legal situation clearly, and it puts Daniel's rights on record. Daniel eventually cleared secondary inspection, but a flag now exists in his file, and the next renewal on the naturalization application he has been planning will be harder because of a conversation he was not prepared for. Be prepared every time. We want to speak directly to you now, not to the case number in a USCIS system, not to the applicant on a form, to you, the person who got on a plane and built something, the person who memorized a new language and navigated a new culture and learned a new system, all at the same time. The person who sent money home and still paid rent here. The person who worked the job nobody else wanted and raised children who will one day lead things. That person deserves to know their rights. That person deserves to be protected. And we want to say something that the immigration system will never say to you. You are not an inconvenience. You are not a burden. You are not a threat. You are a person who kept showing up in a system designed to make showing up difficult. This new law is real. The risks are real, but your rights are also real. Your resilience is real. And your community, the millions of people navigating this exact same system, is the strongest support structure you have. You are not alone in that kitchen at 11 at night. You are not alone reading news alerts with shaking hands. Millions of people are in this with you, and knowledge, shared knowledge, is how we protect each other. Learn the law, share what you know, stand up for your rights, because you belong here, and the law, when you know it, agrees. Before you close this video, think about someone: a parent who does not follow immigration news, a cousin whose green card renewal is coming up, a friend who traveled abroad this year and doesn't know about the new continuous presence rule, a coworker who once received a benefit and assumed it was forgotten. They do not know what you just learned. They are living their life, going to work, raising their children, planning their future, without knowing that the ground beneath them has shifted. Send them this video, not because it will scare them, because it will protect them. There is no price on knowing your rights before something goes wrong. There is no way to undo the cost of not knowing after something goes wrong. One share, one conversation, one person who watches this and takes one of those 8 steps. That could be the most important thing you do today. And you will never even know the disaster you helped them avoid, but they will carry it. And so will their children. Share this. This channel was built on one belief: that the most powerful thing we can give an immigrant is not a lawyer, though a lawyer matters. It is not a form, though forms matter. It is knowledge. Clear, honest, accurate knowledge about what the law says, what your rights are, and what you must do to protect the life you have built. Everything in this video is based on publicly available federal law, official USCIS guidance, and established constitutional protections. This is not legal advice. Your situation is unique. Please consult a licensed immigration attorney for guidance specific to your case. But knowledge is the beginning, and today you have more of it than you did when you pressed play. Stay informed, stay protected, stay here, because you built something real and you deserve to keep it. You belong here.